Hello, my name's Phil Hesketh, I'm a mediator. This is a short video to explain the mediation process. If you're thinking about having your dispute resolved via mediation and want to know a little bit more about what to expect, then hopefully this video will help you. The first and perhaps obvious thing to do is to choose the mediator. All parties have to agree which mediator is selected. Often your lawyer will make recommendations about 1, 2, 3, maybe more mediators, or the other side may have suggested some mediators for you to consider. You can consider those or send nominations of your own as you choose. What I suggest you do is to speak to the prospective mediator. Check out the website, perhaps give them a call, and see if there's somebody you think you can work with, because it's an important day for you, it's an important process, and you want to make sure that the person that you're going to be spending that time with is somebody you think you'll be able to work with. So do get in touch and give them a call. Before the mediation starts, you'll have a meeting with the mediator. Usually it's done on Zoom or Teams, or it can be done on the phone if you're not comfortable with either of those video platforms. The meeting usually takes place with your solicitor present as well, so the solicitor will organise that for you. If you don't have a solicitor, then you can organise it directly with the mediator. And it's an opportunity really for you to tell the mediator what's important to you and what you hope to achieve from the dispute. The mediator won't want to go into too much detail about the ins and outs of the claim, but really help you with any questions that you may have about the process, so that you know exactly what is going to happen on the day itself. When we get to the mediation day, at the start of the mediation, you'll log on to Zoom or Teams, whichever it is, or go to the venue if it's an in-person mediation. And the first thing that will happen is you put into your private room, and the mediator will have a private session with each side. It starts with one or the other. And at your private meeting with the mediator, they will talk to you and remind you about the confidential nature of the mediation. Essentially, when you're in your private room, anything you say to the mediator stays with the mediator. They might take some notes about what you've said, but they won't pass anything on to the other side, not without your express permission. And if you haven't already signed a mediation agreement, then the mediator will make sure that's done at this meeting. Sometimes at the start of mediation, all the parties get together in one room, whether it's a virtual room or a physical room if it's an in-person meeting. Sometimes that meeting is just to say hello to everybody and get to put names to faces on the other side. You may well not have met the other side's lawyers, for example. And sometimes it can be a detailed discussion. But very often, particularly in the kind of work I do, the parties have fallen out quite badly and often don't want to speak to each other. So don't worry, that meeting will only take place if you agree and you actually want it to do so, and of course if the other side agree as well. What will happen if there isn't a meeting between the parties is that the mediator will meet with the lawyers at least and have a discussion with them to explore how we're best going to use the day to discuss any technical legal issues which may need ironing out, and to really hone in and identify what's important to the parties and concentrate time and effort on those things. But eventually one or other side is going to have to start making offers. So the mediator will work with you and your lawyers to develop offers, and they will be passed on usually by the mediator, sometimes in meetings in person, to the other side. And when the mediator comes in, gives you an offer, you can discuss that and talk about that with the mediator, or you may wish to ask the mediator to leave so that you can consider the offer privately with your friends, family, clients, solicitor or barrister if you have one with you. So you can do all of that, and the mediator will really help you develop any responses to these offers What I mean by that is sometimes an offer will come in which you just find offensive. It's not unusual in a mediation for one party to say that the other party's offer is offensive, and the temptation can be to just make a bad offer back, make a very small move, and that's fine. You can do that, but if you do, the likelihood is that the other side then respond in the same way, and you creep very, very slowly to a stalemate. So the mediator can talk that through with you and help you develop strategies to get you to where you want to be with the negotiation. Believe it or not, eventually, after quite a few offers, usually an agreement is reached. About 80% of my mediations end up in a resolution on the day itself. So once we've got that, we usually ask the lawyers to put whatever the agreement is into writing and get it signed by each party, and at that point you have a binding settlement. Now, there may be some other work that needs to be done following the mediation. For example, there might be a transfer of some property, there might be a deed of variation if it's a will, if it's a personal injury case involving a child, then the court will have to approve the settlement, that sort of thing. But the important thing is that your dispute will have finished. That's really all I have now for this brief introduction to the process. If you've got any more questions, then please do get in touch, drop me an email, give me a call. We can arrange a Zoom call if you wish. But thanks very much for watching, and I hope this has been helpful to you.